And I think that historically we were not really prepared. Immediately, the Associated Press got a hold of, initial press releases. There was a lot of press surrounding the opening, the beginning of this court strategy. We don't call it a program. We do wholly adopt the philosophy of therapeutic jurisprudence, but that was really intended more as a communicative message. It wasn't really, it was really supposed to help tell the story of what the court was intending to do. The court really is not interested in keeping people entangled in the criminal justice system. We were using the court, again, very simply as a method of leveling the playing field, of finding individuals that we knew needed to be in hospitals desperately, that we were seeking to intercept them as quickly as possible and get them out of jails and into appropriate, humane treatment systems and services in the community. And so we consider ourselves nothing more than that kind of a human rights strategy. But the press was enormous. And before you knew it, CNN, National Public Radio, Good Morning America, the federal government started coming in. And it wasn't very long before we all locally, everybody that really was playing a role in this court, and the court is very simple in its structure, use a clinical type of approach, a problem-solving type of approach, divert out, and obviously we had our values and our considerations balanced. For example, public safety is paramount to treatment, constitutional rights paramount to treatment, public safety paramount to everything. And so the court had to be voluntary. We knew that. But we also thought that from a humanistic vantage point, from a messaging vantage point, that we knew that the individuals that we would be seeing, we presumed that there was an element of dehumanization, that we wanted above all, whether they opted into the court, whether they chose ultimately to continue in their care, the major message was that we care about you, that we will do anything in the world for you, that treatment works, that recovery is possible, and that through this venue, this strange venue of a courtroom, that personhood could be restored. So the message of personhood that really, over the course, we're now coming into our 12th year, has remained, I think, the most acutely important and valuable part of this court process. The individuals that just keep revolving and have, before Broward, I think, affirmatively decided to stand up. The concept as an American, or I think as any human being, that somebody, anybody who is ill and in need of medical care could somehow find their way behind bars, I have to say is the most appalling human rights violation that I could ever imagine. And to think that, of all places, here in Fort Lauderdale, that with no money and nothing, that somehow we were fortunate enough, and I feel blessed that message has been able to bubble up, and it bubbled up to Congress in 1999. And in 1999, Congressman Strickland, along with former Senator DeWine, along with former Senator Domenici, out of Ohio, of all places, contacted my office and said, you know, we want to file a bill and we'd like you to come. At that point, there were 2 courts, one in Broward, one in Anchorage with Judge Rhodes. And actually, she was doing a small court, but I think at that point also Kings County, Seattle, had started one ultimately. And so with these few models, they were ready to introduce some federal legislation. And sure enough, I watched it on C-SPAN, came home one afternoon. It passed first round, which from my understanding was a very, very rare and unique event, that legislation that gets piloted passes. I know that Senator Kennedy helped out with tweaking the bill, and sure enough, first time out it passed. That had some positives and ultimately even some negatives. But I think that, again, the overall benefit to having the federal government cede money to other jurisdictions that are interested in, you know, developing some kind of, whether it be mental health courts or other kind of court-based diversionary strategies from a recovery therapeutic vantage point, is so keenly important, because the stigma and the mythology and the discrimination that surrounds these illnesses is massive. It is vital to have individuals that are essential in our court system, whether it be judges or lawyers or probation officers, jail officials, finally start looking at these individuals with due respect and dignity, and understand that they don't have a place in jails, and that everybody has a responsibility. Everybody has to take ownership of what happens in this country with the criminalization of mental illness and work to eliminate those disparities. And so I can't really think of a social reform effort that has been so accelerated, that from a time where the criminalization of mentally ill was just really blindly accepted, written about, talked about, policy heads would complain about it in law review articles and so forth. But the fact that nobody was intervening is mind-boggling to me, and particularly in America, of all places.